Does the mere expression of an intention to apply for asylum warrant a detained migrant's release? Or should the migrant go beyond that and show, among other things, a good cause for his illegal entry into South Africa? These are the questions that were pondered on in the Lumbore and others case. While the Constitutional Court ruled that the answer lies in the latter, the applicants submitted before a full bench in the Gauteng High Court that they were not in agreement.
In fact, in Ashebo, they say an immunity, if you have not made an application, you cannot get. Then, yet in Ruta, they said you get an immunity from the day you evince your intention. Then in Desta, which was decided based on the new regulations, then they anchored the same position. So that's where we say they have failed to follow their own judgment. At least they have failed to provide reasons as to why those judgments should not be followed.
Judge President of the Gauteng High Court Division, Dunstan Lambo, put the Apex Court's reasoning to counsel on behalf of the applicant.
And I'll read it to you. It says the absence in the legislation of provisions similar to the old Regulation 2.2 poses an anomalous and highly undesirable scenario that could result if an illegal foreigner in the applicant's position were simply allowed to remain at large on their mere say-so that they intended to apply to seek asylum. I won't read further, but that's where the court started in reasoning why detention may not be unlawful.
Manoj, we don't agree with what...
You don't agree with what the court is saying here?
The applicants who are currently detained turn to the courts to seek their immediate release from detention in fear of being vulnerable to deportation. But the National Prosecuting Authority, which opposed the application, argued that it was premature and bypassed administrative processes already in place by the state.
What this court has been told this morning is that all these that they must be released because they are going to be deported. There is no threat of deportation. They were also told that they are being denied their right to make an application for asylum. That is also completely incorrect. They are going to be given that right. There is a duty upon the state respondents to make sure that they facilitate that right, the rights of those applicants is respected.
This case takes place at a time when the South African government has made its intentions clear of a complete overhaul of the migration system in South Africa. Canny, Maphanga, SABC News, Johannesburg.